Ladies and gentlemen, welcome to Kohler Group's Expansion into China webinar series. This is part 7 of 10 webinar sessions we are holding to help foreign investors not only with their market entry but also their expansion and operation within the Chinese territory. Today's topic is what is legal employment in China and how can one dismiss employees in China. I am pleased to have Dr. Mario Feuerstein, partner at S&B Law in Shanghai, to speak on this topic. The People's Republic of China is known to have a very employee-friendly labor law. This means, for example, that it is difficult for the employer to unilaterally terminate the employment once an employment relationship has been established. Since any unlawful termination may cause severe legal consequences for the employer, it is important for all companies who are employing or going to employ staff in China to have a good knowledge about the labor law and to have suitable contracts implemented to avoid any risks. This webinar will provide you with fundamental knowledge regarding the requirements for a legal employment relationship as well as the requirements for a legal termination of employment contracts. But before we begin today's presentation, I would just like to go through some administration details. If you could hear me, please click on the hand button within the control panel. That will allow me to know that the sound system is functioning. If I am having any audio difficulties or if Dr. Feuerstein is having any audio technical difficulties, please don't exit the webinar. It will just take a few moments for the audio sound to come back and we will then recontinue with the presentation. If you are having any audio difficulties, please go to the audio section within your control panel and change your audio function from your computer mic and speakers to your telephone. As is typical within our webinar series, we do like to have an interactive Q&A at the end of today's presentation. Please don't be shy. Add your questions, your comments into the questions section of the control panel, and hopefully we will have enough time to get to everyone's. For those of you that are new to Kohler Group's webinar series, allow me to introduce who we are. Kohler Group is a CSC company. We have over 120 professionals located within our 10 offices in 3 jurisdictions in Asia. We're located in Hong Kong, Singapore, and in China. Our aim is to help foreign investors with their market entry, their expansion, and all administrative and compliance functions that are associated with their companies within the 3 jurisdictions that we operate in. One of our unique advantages is that we do speak over 10 languages internally and are able to communicate with our clients in their mother tongue. A little bit about myself. My name is Christina Kohler-Coluccia. I'm a director at Kohler Group and I will be the moderator for today's session. I've been working with Kohler Group since 2003 when I first opened our Shanghai office. I've expanded our China operations to having 8 offices within the Chinese territory. I've been advising Western clients with their market entry, their expansion, their operations, and in some instances their liquidations from the Chinese market. Kohler Group produces a wide range of resources in the form of magazines, alerts, and we publish these on our website. We also have all the up-to-date information distributed through our e-newsletter. If you are interested in receiving it, please go to our homepage on our website and insert your email address into the section entitled ChinaInvest.biz Information Series. Now, without further ado, I would like to welcome Dr. Feuerstein to begin his presentation. Dr. Feuerstein?
Yes, thank you very much, Christina, and welcome to all in this webinar. Yeah, let's start. On the table of content, you see what I will present to you today. First, I have a short introduction to myself and my law firm S&B, and then I will give you some basic on Chinese labor law, because this is necessary to really understand what is the legal employment in China. And then I will go into details with regard to the conclusion of labor contracts. So I will talk here about who can be the employer, who can be employees, when the labor contract will become effective, and what kind of content the labor contract must have. I will give you some do's and don'ts, and give you some examples, and also then will tell you under which conditions it is possible with contracts either by the employee or the employer. And then in the end we have a Q&A session. Christina, please, next slide. So I'm a German attorney at law with a PhD in Chinese law. I'm working here in Shanghai as a lawyer since 2005. And as Christina already mentioned, I'm a partner of SNB, Schulz, Nork, Beerwinkel. And I'm specialized in corporate law, labor law, and contract law, and dealing with employment questions on a regular basis. Next slide, please. Schulz, Nork, Beerwinkel, SNB is a German law firm. Our headquarters is in Hamburg. We have in Germany also one office in Rostock, and besides Shanghai, we have also an office in Ho Chi Minh City, and we are also present in Indonesia with a cooperation with the Indonesian law firm. We have been the first German law firm who has established its office in Shanghai, and this was in 1995 already. And our main practice area are, as I already mentioned, corporate, including, for example, restructuring issues, M&A, relocation, joint venture setup, labor contracts, negotiations, all kinds of situations, dispute resolution, and we are also working in the area of food law, healthcare, and in particular, we have a strong IP department who is also, for example, dealing with patent infringement. Next slide, Christina, please. Basic information on Chinese labor law starts always with the question what kind of regulation we have here in China, and we have quite a lot. As you see here on this slide, which is just a short selection. The main law is the labor contract law. Besides that, we have the labor law, and then you have a lot of regulations on the national level. But what is very important to know in labor law is that we have also local regulations. That means if you check a labor question, then you also have to find and look into special local labor regulations. For example, in Shanghai, in Jiangsu, and so on, because these local regulations could have detailed rules on issues which have not been explained in detail in the major national-wide laws and regulations. Sometimes these local regulations are also in conflict with national regulations, and then you have to figure out whether the local regulations may prevail or whether you should apply the national regulation. Next slide, please, Christina. Now some very general principles of the labor contract law, which is important to know, because if you violate one of these principles, it could have that you have severe negative impact. For example, the employee could terminate the labor contract, or they could ask the authority to level a penalty on the employer, and so on. So it's important to have a good knowledge also of the general principles. And these are, for example, lawfulness, fairness, good faith, free will, and free negotiation, in particular of the labor contract, and equality. So it's not allowed to make any discrimination, for example, with regard to nationality, race, religion, or sex. And women enjoy the right employment rights than men. Next slide, please. We have also labor unions in China. Actually, we have probably the biggest labor union in the world, the so-called All China Federation of Trade Unions, which has, as of 2014, 280 million members. So this does not mean that all companies in China have trade unions, but employees have the right to establish trade unions in any companies, also particularly in foreign-owned companies. And this is not necessarily a bad thing to have a labor union in a company, according to our experience, because it quite happens very often that the members of our representatives of the labor union in this situation try to help also the company to solve the problems. And sometimes we have the impression that the employees think that the members of the labor union are more on the side of the employer than of their side. So do not be scared if you hear that your employees want to establish a labor unit. It's not necessarily a bad thing which happens. And next slide, please. And the basic rights of the employees can be summarized as he has the right that he is employed on an equal base and obtain equal remuneration for his employment, that he has the right to take rest, have holidays, and paid leave, receive labor safety and sanitation and protection, get training and professional skills, enjoy service, social insurance, and welfare treatment. And in the case of a labor dispute, he can go to first to the labor arbitration, and then he also can file a lawsuit, for example, with the People's Court to solve the labor dispute with his employer. Next slide, please. So the first question is, when will a labor relationship be established? This is the time when the labor contract is signed. No, not necessarily. The date is when he starts to work for the employee. So that means that you can sign the labor contract earlier and with the date in it when the employee shall start his work, and with this point in time he starts his employment relationship. Which obligations have the parties? For example, the employer shall faithfully inform the employee on the work conditions, so he must know in advance already what he has to expect. The conditions and the location where he has to work, and whether any risk of occupational harm is involved with the work he's doing. Also, the employer also has to give the employee information about the safety statutes, about the remuneration, and also other information which the employee may request. On the other hand, the employee also has the right to have information from the employee which are directly connected to the employment contract, for example, regarding his education and experience in the work he will be applied for. It is not allowed that you keep the identity card from the employee or other certificate, that the employee gives to the employer some kind of guarantee money, something like this. This is strictly forbidden. And the labor contract must be a written contract. To this issue I will come later on a separate slide in more detail. Next slide, please, Christina. So if you have or want to have a labor relationship, first question is, who can be the employer? This sounds like a simple question, but it is not, because we have here some restriction which we have to consider. Of course, you can be the employee if you as a foreign company have established a foreign entity here. So, for example, a WUFI or a joint venture with a Chinese partner. So this company has the legal status, and in this situation, it is no problem that this legal entity employs Chinese employees and or foreign employees. What is about a representative office? Probably you already know, representative office is not a legal person according to Chinese law, and it is not allowed that a representative office employs Chinese employees. If you want to engage in Chinese employees, then you have to go through a Chinese labor service company. We have a couple of them, for example, FESCO or CIIC. These will, after they have signed a labor contract with this employment, then dispatch these employees to the representative office. At the same time, the representative office will enter into a service agreement with this service provider. And that's quite a complicated relationship, and here you have to be careful about the contract, especially with this labor service contract company, because they try to shift all the burden of the risk to the representative office. With regard to foreign nationals, here it is possible that the representative office register up to 4 representatives, and basically these representatives could be directly employed by the representative office. Next slide, please. Other question which we encounter in practice quite often is whether or not a foreign company, that means a company with no establishment here in China, can enter into an employment relationship with Chinese citizens here in China. And here the situation is that it is not allowed. You're not allowed to do this. And the basic rule is only after you have an establishment here in China, you can employ Chinese citizens. In the next slide, please. So now we have clarified who can be the employer. Then the next question is who can be the employee. Also here are some details which we have to consider. First, no child labor is allowed in China, and that means the employees are not allowed to be under 16, except for certain situations, for example, arts, sports, special skills. But for this, you need an approval of the respective labor authority. And what is about foreigners? Can foreigners be employees? Yes, you can say of course, but as you probably know, requirement for a foreigner to work in China is that he has a work permit, and this getting somehow more difficult, or has become more difficult in the past years, and because the foreigner must have certain qualifications with certain conditions to have the visa. And so if you want to employ a foreigner here, you also pre-check already whether he is eligible for a working permit in China. Christina, next slide, please. What is also important that upon retirement, we do not have an employment relationship anymore. And in China, the situation is currently that the retirement age is very early. So for male, it's 60 years, and for female workers, 15 or 55 years. And the situation is upon this age and upon the receiving of the pension, we do not have an employment relationship. And that means that also the employment law and all employment-related provisions are not applicable anymore. And we have more or less a service agreement or service relationship, which is not an employment relationship between the company and this retiree. But here they are quite, it is not 100% sure whether or not the courts in some situation would apply labor law, maybe analog in specific cases. So this is an area where you have to be a little bit careful, because it is not 100% clarified by the courts and by the law. The next slide, please. So, if you want to enter into the labor contract and you are certain that you are eligible to employ this person as an employee, you have to think about what shall be the content of the labor contract. And in the first thing is that according to the labor contract law, you need to have a written labor contract. If this contract is not in writing, the company is running into the risk that they have to pay double the salary for a period of 1 year. And so that means it is in your own interest to have a written labor contract and that clarifies all the necessary details of an employment relationship. And this labor contract must be in writing latest 1 month after the employee has started to work. Christina, next slide, please. So when the labor contract will be enforced, so after signing, basically, and you know, as a company, you normally also affix your company seal in addition. But as I said before, the labor relationship only starts with beginning of the work. And it is, in general, feasible to have a probation period included into the contract. And the length of this probation period depends on the term of the contract. So, for example, if you have a very short contract between 3 months and 1 year, then the probation period shall not exceed 1 month. If the term is 1 to 3 years, then the period shall not exceed 2 months. If the labor relationship is more than 3 years, the probation term shall not exceed 6 months. And you only can have one probation period for the employer. That means maybe after the term has expired and you want to enter into a new labor contract with them, you should not have the probation period for this time. And if you have a labor contract which is shorter than 3 months, or if it's only with regard to the accomplishment of certain tasks, then it is not allowed to have a probation period at all. Next slide, please. Christina. The labor contract law has a list of issues which must be included in the labor contract. And this is employer's name, domicile, the name of the legal representative or major person in charge, the employee's name, his domicile, identity card number, or other valid identity certificate numbers. And it should mention whether this employment relationship is a fixed term or non-fixed term. And it also has to state the remuneration and with regard to whether or not it's the employment relationship is a non-fixed term or fixed term relationship, you have to be careful because it could be that the labor relationship automatically will be converted into a non-fixed term relationship. And this is, for example, if the employee is working for the employer for 10 years consecutively, or if you have fixed-term labor contracts and you have renewed these contracts already twice and want to enter now into a third fixed-term contract, then this is not allowed. At that time, you have to enter already into a non-fixed-term contract. Christina, next slide, please. So further content is the job description, work location, working hours, break time, remuneration, as I already mentioned, social security, employment protection, labor discipline, and so on. The more detailed the labor contract is, the more chances you may have, for example, to terminate the labor contract later. I will explain this a little bit later in connection with the termination possibility. And besides the labor contract, and this is also important to know, you could consider to have also company rules. And also with regard to this topic, I have a separate slide with some more information. Next slide, please. And what is also typical in a labor contract is to have a confidentiality clause, which can be entered into the contract. And basically the confidentiality you also could or can extend for the time after the employment relationship has ended. But what is also quite usual in the practice here in China is to have a post-contractual non-compete clause. So that means the parties agree, the employer and the employee, that after the employment has ended, the employee shall not be allowed to work for a competitor. But such if you, for the time of the non-compete obligation after the labor relationship, the employer is paying economic compensation to the employee for this period. How much this compensation must be depends on which local law applies. So this is a typical example where local law is quite important, because different locations have here different requirements. So it could be 30%, but also could be 50% of the previous average salary before the contract has ended. So here you have to be very careful to make sure that you have a valid non-compete clause, because it could be that this clause is invalid if you haven't drafted it according to the laws and regulations. And for these clauses, you should be very precise and very detailed. For example, should include, for example, the name of competitors, for example, and the scope and geographical range and the time limit for this post-contractual non-compete. Let's see the next slide, please. So, regarding termination. First of all, it is up to the contract parties, the employer and the employee, to agree on a termination of the labor contract through amicable consent. This is quite tricky for the employee, because according to the regulations, if the employee has asked the employer to terminate the contract or enter into this negotiation, then he may lose his claim for compensation. So this is a topic which both sides have to be carefully consider when they enter into this amicable agreement on the termination of the labor contract. And there are some situations in which the labor relationship automatically is terminated. I have listed here 5 examples, basically. First is when the term has expired, yes, or if the employee has begun to enjoy basic benefits of his pension. As I already mentioned before, then we do not have any employment relations anyway. Also in the case that the employee has deceased or is declared dead or missing by the court, civil court, or in other cases if the employer is declared bankrupt. So also in this situation, the contract is terminated. Or if the employer, the company's business license has been revoked. With the next slide, please. So the employee also has the right to terminate the contract, and in the cases which I mentioned on the slide on page 25, the employee can terminate the labor contract without notice. For example, in the case that the employer fails to protect the employee during his work, or in the way the working conditions are not as stipulated in the labor contract, or if the employer fails to pay the remuneration timely, and so on. So that means if you want to avoid that maybe an important employee of your company terminate the employment relationship, and in this case he is eligible also for compensation, then you have to make sure that none of these cases happening. So that's also for HR, I think, very important that they make sure that they are really having a legal relationship, which basically means that also conditions, for example, in the labor contract are fulfilled. Otherwise, it's a risk that the employee terminates, and if it's an important employee, then this could be negative for the company. Next slide, please. Christina. The employee has also, anytime, has the right to terminate the employment relationship with 30 days notice in advance. So that means that you cannot avoid. But the difference is to the previous cases, if he terminates the contract with the 30 days notice by himself, then he has no right to claim compensation. So then it's more or less, a lot of cases, unlikely that he will do this. And if he is doing it, at least the company has not to pay compensation. In the probation period, he can terminate the contract with the 3 days notice. Next slide, please. And now we come to the cases where the employer has the right to terminate. And here, we have cases where an immediate termination without notice is applicable. So, for example, in the first case, if the employee is sick or injured, but not work-related, and the statutory period for medical treatment has passed, but the employee is still not fit to continue his work. In this case, the employer can terminate the contract. And here, of course, the interesting question is how long is the mandatory period for medical treatment? And here we have listed for you the stipulation in the regulation. It's based on work experience, so even not on the employment, the term of the employment relationship with the employer, but with work experience. And you see, the idea is the more work experience the employee has, the longer is also this medical treatment period. For example, if it's shorter than 5 years, then the period would be 6 months. And if it's 20 years, then it's even 24 months. So that means the longer the employment, also the longer the employment relationship endures, the more experience he has, and the more, the longer is the medical treatment period. Next slide, please. Also, a termination reason is if the employee is incompetent to his position still after training. What does it mean, incompetent or incapable? So that means that the employee is not able to complete the required work agreed in the labor contract, or the workload of the same type of work with the same post staff. Here you see why it's very important to stipulate in the labor contract the exact working requirement. So the more detailed this description in the labor contract is, probably the more chances you have, better chances you have to find a valid reason to terminate the employment contract. But of course, you have to play fair. You're not arbitrarily, for example, can increase the quota for the output of the employment work in a way that it is impossible for the employee to complete the work. In this kind of case, of course, you are not eligible to terminate this contract. Also, termination reason is if the objective circumstances on which the labor contract has concluded has changed. And for example, if a department has to be shut down and it's not necessary to have this work anymore, this would, for example, be a reason where you can refer to this termination reason. In Article 41, we have of the labor contract law, we have also a stipulation regarding mass layoff. And here, the rule is that if a company wants to dismiss 20 employees or 10% of the labor force, then the company has to go through a mass of procedure where the labor union as well as the authorities are involved. So you have to make a mass of layoff plans and show it to the labor union and also to the trade union. And it is only allowed to do this under certain conditions, which are, for example, if the employment unit undergoes restructuring according to the bankruptcy law, or if the company has serious production and operational difficulties, or if the company undergoes a change of production or a reform of technology, etc. So in these cases, you have the chance not only to lay off one or two employees, but also make a mass layoff in the magnitude mentioned in the law. Next slide, please, Christina. So when can you immediately, without notice, terminate the labor contract with the employee? We have in Article 39 certain conditions. For example, if the employee does not meet the recruitment conditions or the employment criteria during the probation period, if the employee violates rules and procedures established by the employer. So this is also a reason why it's important to have, for example, company rules, because if you have written company rules which are validly introduced into the company, then a violation against these rules, if they are seriously, and it is advised to exactly define in the labor rules or in the labor contract what is seriously, then you have a good chance that the court in China will help your termination of the labor contract. And so on. There are some more examples, and even if the employee is under criminal prosecution, it is possible to already to terminate the employment contract. So it's not necessary that there's already a verdict by a court which proves that he is guilty, but only already the prosecution is good enough to immediately end the labor relationship. And next slide, please, Christina. But there are some exceptions for the employer to terminate terminate the employment contract with notice, which are listed here on slide 13. For example, if we have work-related illness, occupational disease of the employee. In this case, it is not allowed to terminate the labor contract, and also it is not allowed if the employee has lost partially or completely due to an occupational disease or work-related injury his capacity to work. In this case, we have special regulations which are dealing with this and what the employee has to do in this situation. Also, for example, if in case of pregnancy, you are not allowed to terminate an employment relationship. And also, it is not allowed if the employee has worked 15 years at least with the employee and is 5 years before his retirement age. Christina, next slide, please. So, what happens if you have an illegal termination of the employee? Then the risk is that the employee can ask for that the employment relationship continues, or he can ask for twice the statutory compensation payment. Please, let's go to the next slide. Yes, this is somehow a summary of what I said before with regard to the notice period. What is maybe also important to know is if you have want to terminate a labor relationship with a 30 days notice period, then you can avoid it, the 30 days period, if you pay the employee an additional extra month salary. So in this case, you can immediately end the labor contract. Next slide, please. Here I have to mention some rights of the labor union. So basically, they have to be involved in the case of termination, so they have to be notified. They have the right to litigate between the employee and the employer. Next slide, please. Maybe we also already switched to the slide number 35. So it's more details about the compensation. In case of illegal compensation, basically, if you terminate according to the 30-day period reasons, then you have to pay the compensation, or also if it's a restructuring or you have a mass layoff, in all these cases you have to pay the legal compensation. Next slide, please. So it is calculated, the legal mandatory compensation is calculated according to the employment terms. So if the employee was only employed for less than 6 months, then it's half a month's wage. If it's more than 6 months but less than 1 year, then 1 month's wage, and more than 1 year, then for each employment year it is 1 month's salary which you have to pay. But there is a cap. So if you do not have to pay more than 3 times of the local average salary, and we have also a cap regarding the years, not more than 12 years. This applies not only for Chinese employees but also to foreign employees. We have here on the slide some examples how much the average monthly salary was in 2015. You see Beijing 7,086, Shanghai 5,939, Shenzhen 6,753. So this you have to calculate 3 times. But yeah. So next slide, please. And here I have some information regarding a strike, because in the last years we have very often that employees start to strike, and it is quite, the legal consequences are quite unclear, because we do not have in the national laws and regulations really a clear answer to this, whether a strike could be legal or not. But from the practice, I think the opinion of most of the labor authorities or courts is that it could be that there is a legal strike in cases where, for example, the employee has not fulfilled his contractual or mandatory legal obligations. If in this kind of case the employees lay down the work, not working, then this strike would very likely be regarded by the court as legal. But we recommend to have also in the company rules a clear definition and stipulation under which circumstances, in case of a strike and termination of the labor contract without any notice is possible. Yeah, I think we're running a little bit out of time. Shall we stop here and enter into the Q&A session?
Let's do that. Thank you very much, Dr. Feuerstein. For all the attendees, just note that the presentation will be distributed to you. So the last remaining slides we didn't go through, you will be able to read them at your own leisure. We did have quite a few questions come in. The first two are related to each other. You had mentioned at the beginning of your presentation that no foreign entity could employ someone who's residing in China. There's an attendee who's asking the question for clarification. Does this even include Hong Kong companies? Can Hong Kong companies employ or not employ individuals that are residing in China?
I must say I'm not 100% sure whether we have in the CEPA agreement something in special regarding the employment, but basically it should apply to all foreign companies. But this I really would have to check whether maybe there is an exception in the bilateral agreements between China and Hong Kong.
A related question, and this is coming from myself, which is a question that a lot of clients of mine forget to ask, but it's basically the situation they're in. We have a lot of clients that don't have an entity registered in China, but they have had a mixture of email communication with individuals residing in China, basically imitating terms and conditions of an employment contract, but nothing has been signed or chopped. Now, for me, this definition of this type of communication would be as a freelance agreement. What is your perspective as a lawyer based in China? What is your perspective on freelance agreements? And what is your opinion of companies who do all the communication via email versus having a proper employment contract in place? Are the emails still useful and viable when going to a labor arbitration or to court?
Yes, they can be used, but the problem is if the email is coming from abroad, then you have quite a strict requirements regarding how to use it in court, because then you have to notarize and legalize it. For all evidence coming from abroad, it must be legalized and notarized, and so you have to find in your home country a notary which will legalize and notarize that you have sent out these emails. That can be quite tricky and complicated. So we we would advise not to have this and have a real a contract, because emails are normally not sufficient to really put all the things which you should regulate into the emails. But basically, especially if you have a labor contract. But the other question you asked, whether this kind of model is really is it a freelance relationship or is it a labor relationship? And that's a difficult question which cannot be answered in general, because for a labor relationship, you have to have some requirements. For example, the employee must be integrated into the organization of the employer, and he has to follow the rules, so he has no freedom, because a freelancer maybe also has the right to work for someone else, and then you can argue this is not a labor relationship. But of course you're running into a risk. If this is unclear, then there is a risk that it will be challenged from either from the employee or the freelancer or from the labor authorities, that you really have to think about, and there is remaining risk in this kind of situation.
And what is your suggestion to companies who are not ready yet to make the investment to establish a company in China, but they still want to have people on the ground? What do you tell companies that are in this situation in terms of employment and labor relationships? How do you deal with these complex issues?
Well, you have the possibility to at least set up a rep office, right? So if you need something here to do market research, then the proper form would be the rep office, right? Or you have some, as you said, freelance agreement. So you can have a service contract with someone, and you have, if you do it properly, then he's not your employee, but he's just rendering to you some services which are not employment services. So I think you can manage this, but it depends on what do you want that these people you engage in China shall do.
The next question comes from an attendee in relation to foreign employees. What is the trend that you see right now in the Chinese market? Are foreign employees sent on secondments, or do you see more that they are signing local contracts?
From our perspective, it's very hard to avoid at least the formal local contract, because the Chinese labor authority is asking to see the Chinese labor contract. So normally they are not satisfied if you show them a secondment agreement, because they do say they do not really understand that that's a foreign contract, and you should show me a proper local contract. And that means that many of our clients then enter into formal local contracts, which of course also could cause some problems, because then you have the local contract, but then you have another contract with the foreign company, and this should be prevailing. And what happens if in the case of a dispute, right? Because this is that's a problem in the which could arise if then the employee has a dispute with the employer, and then he says no, the local contract is applicable.
Exact. Another question that has come in is in relation to companies that have initially representative offices in China, but they expand and either they go into a limited company or into a joint venture relationship. They want to maintain the employees, obviously, but to go from one structure to another, new contracts have to be signed. And for a lot of employees, their concern is, is their previous years of employment still counting towards the whole relationship? What do you advise companies in that regard?
You can include this into the new labor contract, so you can say that the previous time in the representative office will count as time worked for the new entity. This should be good enough to protect the interests of the employees. or you have to pay them out, then through, for example, Tesco, because as long as you only have a representative office, then you have no direct employment relationship with these people, because they are legally employed with this Chinese service companies, like, for example, Tesco or CIC. But you can transfer legally by the new labor contract the time in the rep office as time spent in the new company.
The next question is in relation to your slides related to the labor union. An attendee was asking, even if he has one employee in his company in China, does that mean a union can be formed?
I think there's a minimum requirement. I think it must be at least 3. One, I think, I do not have the regulation now in my head, but it should be more than 1, and if I recall correctly, then it's at least 3.
So two more questions that have come in. If a company exits China, so they're liquidating their operations, and they have less than 20 employees, do you still terminate the employees one by one, or are you able to do a mass layoff?
I think this would be similar to the case bankruptcy. I think you have to do this mass layoff and have to inform the authority that you are terminating them. But you remind there might be an automatic termination of the employment relationship if the business license, for example, is revoked or the company registered. So I'm not 100% sure, but so if the situation is that you liquidate the company by a board resolution, right? There's no bankruptcy case involved like this, right?
Okay.
I must say I must check the regulation again. I cannot give a certain answer to this.
And then the last question is actually from me. It's something that I want to maybe just emphasize a little bit more to the attendees today, and I'm backing what Dr. Feierstein has said throughout his presentation today. Employee handbooks, where you have guidelines and company laws. I think this is a lot of the time something that companies forget to do, particularly when they're in their startup phase in China. They're concentrating on how to employ people. The next step is thinking about employment contracts, but really they hardly ever go into the details of creating an employee handbook. And as Dr. Feuerstein has mentioned throughout his presentation, it is critical to have some type of guidebook where you can fall back on if you are looking to terminate staff or formulate trade unions or whatever the case might be, that you have something written on paper that has been reviewed by your staff, signed off by your staff, that really follows your company policies. I can't emphasize that more.
And maybe I add one more point with regard to this. I think I have a slide on this, but I haven't mentioned it. It is very important that you legally introduce the company rules into the company, because there is an Article 4 in the labor contract law which precisely explains what you have to do to introduce this kind of rules into the company. And that means you also have to involve the employees and the labor union, because the employees and the labor union must have the chance to give their suggestions to these rules. And to our experience, many companies would like to avoid this because this may cause trouble, right? If you start, especially if you have a large or many employees, then you really, if you start a discussion, then you're not 100% sure what comes about the outcome of this discussion. So many companies try to avoid it, but if you avoid it, then you have the risk that someone can challenge these company rules, and someone can argue that these rules have not been implemented according to the legal procedure, and and are invalid for this reason. So
Right.
you have to be very careful.
Well, we have run out of time. We're now at 6:05, so I think we will leave all the questions there and leave the presentation there. But just note, as mentioned, everybody will be receiving the slides of today, and you will have the contact information of Dr. Feuerstein, so you will be able to reach out to him should you want more clarifications or you have more questions you would like answered. So I do want to take this opportunity to say thank you to Dr. Feuerstein for joining us today. Thank you for presenting on such a complex topic, and I hope everyone was able to get some insight into it. So thank you very much.
Thank you.
If anybody would like me to make a formal introduction, don't hesitate, just email me and I would be happy to do that as well. And last, administrations, we have 3 more webinars up and coming in this webinar series. If you've enjoyed the last 7, then please do register and participate in the last 3. And last but not least, if you are interested in subscribing to our resources, it can be easily done so on our homepage. I want to wish everybody a very pleasant evening, and thank you for joining us, and hope to see you again soon. Thank you and goodbye.